Good evening, everybody. Welcome to our sixth webinar at least. Sorry, I still need to get that sorted out. Welcome to our sixth webinar in a series of webinars on the national state of disaster and the regulations which have been promulgated in accordance with such state of disaster. Today there are three of us who will be presenting. We'll be speaking about Advanced Alert Level 3, pursuant to the President's announcement last Wednesday. I think it was the 17th of June. And tonight it will be myself, Lucian Lewin. I'm a director at Dingley Marshall. We've got Matthew Thompson, who is a senior associate, and Megan Scott, who is an associate with our firm. We all work in the litigation department. Each one of us will be speaking about a pre-selected topic relating to the Advanced Level 3 regulations promulgated. We'll also be speaking about answering at least various questions which have been posed by attendees during the last couple of days leading up to this webinar. And we're also going to be looking at developments in litigation relating to the regulations and where we are on those court matters. I will be speaking about the Advanced Level 3 announcements by the President last week and the subsequent regulations published. Megan will be dealing with various questions, as I said, posed by participants in this webinar submitted over the last couple of days. And Matthew will be talking about the controversial legal challenges. I have drawn a short straw because I think that the regulations which I am dealing with are quite dry, to use, for lack of a better word. It's not the most exciting, but I think it's important for people to understand, and it definitely is exciting for the people who are affected by these regulations. So let me kick it off. The President's speech of 17 June, Advanced Alert Level 3 list of permitted services in an effort to open the economy even.
I see Lucian's internet connection is timing out momentarily.
Sure. I think we're actually waiting for more
specific accommodation.
There we go.
And other than sharing of personal accommodation in the form of Airbnbs and cinemas. I believe you guys are losing me a little bit. Is that a problem? Matthew, can you hear me? Megan?
I can hear you now. I think maybe just if it happens again, disable your video.
There is a problem with this now. Let me just see. Hello, Matthew?
Yeah, we can hear you. Okay, well, while we wait, I think Lucian is not aware that his microphone is muted for now. I can see that it's muted from my side. Meg, sorry, Lucian's back now. Lucian, can you hear us? Microphone on and off.
We are still waiting for a few more people to join, so.
Okay, I think, yeah, maybe let's keep chatting for now. If Lucian doesn't join us, we might just need to push on to our section. So yeah, Lucian was busy introducing and maybe clarifying for a lot of people what the current status of the lockdown regulations are. You know, we started off with what we now know to be sort of the hard lockdown, alert level 5, as government has now branded it. At the beginning of May, we shifted across to alert level 4, and from June, we've been in this sort of new normal of alert level 3. I think the President's speech caused a fair bit of public interest last week. I believe the announcement was on Wednesday or Thursday, if I recall correctly. And actually, it raises a few questions, just, the timing of the president's speech and whether or not these regulations then become of force from that date. I know we, as the panelists, we were talking about it earlier today, and it's certainly something that I've been asked about quite a lot during lockdown. And, perhaps frustrations have been expressed about the perceived delay between what the president announces and what ends up being law. I think, probably the most notorious instance of that was at the beginning of Alert Level 4 when President Ramaphosa announced that cigarettes would be for sale. And there was a perception that Dlamini Zuma had countermanded that by publishing regulations within, which then did not allow for the sale of cigarettes. I see Lucian's back with us. Lucian, I hope your internet connection's doing a little bit better.
Sorry about that.
That's fine. Just to bring you up to speed, we were busy just discussing the issue of the current status of the regulations that we're in Alert Level 3, and we were just about to clarify sort of Ramaphosa's statements from last week, and then also just noting that essentially, a statement by the president doesn't necessarily mean law. Is not a regulation, it's not a directive or a direction, and it's only really when these things are published that we have a law to examine and to consider. I think that's roughly where you were headed off. Perhaps you'd like to pick it up.
Yeah, absolutely. I mean, there's been a little bit of criticism I've been listening to on the radio over the last week or so about the way that the presidency delivers their speeches, because it's not law when they make these announcements, and then you have a sort of a waiting period before the laws are actually enacted. It creates a lot of confusion, and especially when we had the issue earlier in the year when he announced that smoking would be permitted in level 4. And then when the regulations came out, they changed their minds. And there's been a call for the president to actually make these announcements once the regulations have been prepared already, so that he can make the announcement and the next day that regulation can just be published. And it's not a case of having to start drafting the regulations in accordance with the president's speech. I'm not quite sure how they do it, but it does seem strange that one waits as long as we do for the regulations to come out. The regulations which have been published thus far, I don't know if you've spoken about that, Matthew and Megan, but they deal, so the only regulations that have come out deal with the personal care industry. That's your hairdressers and your barbers and your tattoo artists, and then the sports, arts and culture, the Department of Sports, Arts and Culture, dealing with professional sports specifically. No regulations have been published at this time permitting restaurants opening for on-site services, accredited tourist accommodation, and I think cinemas was the other issue which he had spoken about, which would be open subject to stringent health protocols, which, we still don't know what that is at the moment. So you can take it that those things are not illegal. If you're going to a cinema later after this webinar, you will be breaking the law. If you're sitting in a restaurant while listening to this, which would be really sad, but if you are doing that nonetheless, you are breaking the law. You should not be sitting in restaurants at this point in time. So I'm going to quickly run through these regulations that have been published in respect of these small business development directions relating to barbers, hairdressers, tattoo artists, and then of course the regulations which deal with sports, arts and culture. So the small business development directions by the Minister for Small Business Development dealing with the barbers and hairdressers. The scope of these directions is such. They've basically been issued to assist categories of services in the personal care service industry which have been deemed as safe to resume operations. These categories are hairdressing, barbering, nail and toe treatment, facial treatment and makeup, body massage, tattooing, and body piercing. It sets out protocols under which these services may operate. So obviously your usual social distancing, sanitizing or hand washing, using PPE, all of those kinds of things. It specifically says in the regulations that these permitted services may only commence with operations once they have ensured compliance with the relevant protocols. And furthermore, they did divide the various types of businesses into formal salon premises, informal salon premises, formal tattooing and body piercing studios, and informal tattooing and body piercing studios. The various protocols that were issued do not replace previous regulations and directions dealing with protocols, but simply add to it. So they relate, as I said earlier, to hand washing, social distancing, use of cloth masks at all times, and then they refer to and more protective masks for close facial contact. I'm not quite sure what that means. And the regulations don't explain what that actually means, but I suppose it's saying a cloth mask is not going to be as effective if you're right up in the person's face as you would be if you're cutting their hair or working with their heads. And of course, the usual cleaning and disinfecting of touched areas and equipment is important. Yeah, so other things that they've asked for are regular cleaning of premises, PPE, face shields to be worn by stylists and cleaned after use with each customer. So it's not just the mask they require, but those actual transparent shields which go over their heads. They encourage pre-booking to avoid queues. 1.5 meter social distancing between customers needs to be ensured. And an interesting thing, they say employees with comorbidities must be discouraged from working. There's no compulsion that they are not to come, so there's no prohibition on people with comorbidities. Doesn't deal with either, also whether they would be, such people would be paid should they not come to work because they have some sort of comorbidity. And then finally, they also require that you maintain, a hairdresser needs to maintain a register of customers and persons who are treated on each day for traceability purposes. So if you find out, they find out later that one of them have COVID-19, one of the hairdressers, they can actually call each person customer was in the shop the day before and can say, listen, you need to self-isolate now for 14 days because we've got a confirmed case of COVID. So that sort of summarizes. It's a lot longer. I'm not going to go into the boring detail of each and every provision relating to hairdressers. If you would like advice, if you are a hairdresser or if you want to go to a hairdresser and you would like a more formal advice on this, please feel free to contact us.
Lucian, maybe I might be skipping ahead of the queue, so please stop me if you feel so. I think the publishing of the hairdresser regulations, if you can call them those, has sort of an interesting story, and it sort of talks to government's approach during the lockdown to certain legal challenges.
Yes.
Maybe it might just be worth noting, you and I and Megan were sort of following it quite closely. We worked with some of the council who were involved with that matter. And I think it's one of the industries that certainly attracted a lot of sort of public interest during this time. In as much as we all need to, eat and drink and, get food supplies from groceries, a lot of people consider personal care services such as the ones that have now been opened up to be a really integral part of their lifestyles. I know we've seen the lockdown beard craze. Mine obviously started long before that. We've seen many people sporting afros and longer locks than usual. And it's because they haven't had access to hairdressers, to barbers, to nail salons like they usually would. And you and I obviously followed quite closely the case of Carlo Fuyun versus the Minister of Cooperative Governance and Affairs. And that was an interesting challenge that came in and out of the Western Cape High Court. It seemed to attract quite a lot of public interest, and perhaps more so than some of the other challenges that we have seen, because people have been waiting for this particular type of industry and service to open up. And as you know, the High Court ruled against him initially, but that challenge was then followed up by what I consider to be a slightly stronger legal challenge from the Democratic Alliance. And as far as I'm aware, it was really a result of that challenge that the government sought to amend the regulations, because obviously as soon as, if the government changes the regulations which are the subject of a challenge, the merits of the challenge essentially become moot, and it is a strategy to avoid losses, if you can call it that.
It's actually a strategy which I think people are employing at the moment, of trying to enforce legislative change through the courts. So people are going, listen, we're going to try and strike that regulation down. But if the government looks at it, if the let's say the Minister of Cooperative Governance and Traditional Affairs looks at these papers challenging hairdressers and goes, oh my word, these are actually good papers. There's a strong argument made here, and I could lose. They may say, well, let's change the law quickly so that it renders this whole application moot, and we don't have egg on our faces when the court says, listen, you guys were irrational in what you've done. And I suspect that may have happened with the hairdressers argument, where you found that quickly while I think they argued the matter already, Matthew, by the time that the alert level 3.
As I understand, the applicant in the matter, the DA, got sight of the government's proposed regulations and had some sort of comment and feedback opportunity. And that was shortly before the government filed their answering papers. So that was on the 17th or the 18th of June. And then the matter was actually set down to be argued on the 22nd of June this week, but was then parts of the application have been postponed for a hearing at a later date, because obviously the regulations were published last week, Friday.
Yeah. So it's an interesting tactic where you actually go litigating, not for a win, insofar as a win is a court saying you're right and the other side is wrong, but it's actually trying to force the government to actually change from their own by instituting such change themselves. So it's a worthwhile consideration in terms of actually, and it's an interesting sort of slant on the traditional idea of litigation and what a win and a loss is. But yeah, that's a good point that you raise. Oh, by the way, I think Matthew, you mentioned to us before this that there are about 160 challenges against the government pertaining 116 challenges since lockdown started.
That's according to an answer given in the National Council of Provinces by Dlamini Zuma or one of her underlings. So it's a fairly significant number. I mean, that's 3 months only. That's pretty much a challenge every day in 3 months.
I think the only thing I could probably just add to the hairdressers thing is that because it influences so many people, and there's like so many jobs, and mainly women that obviously are doing those jobs. So exactly what Matt was saying in terms of it is an essential service, but just the amount of people that was going to affect, and it's their income, it's the only income, some of them. I think that's also why it got all this attention. Obviously, exactly what you're saying, Lucy, and it's an interesting shift in terms of going through the courts. But just in terms of like the interest in it, I think was just coming from that point where it was 3 months, these ladies, and obviously men, in these fields that weren't been able to work and earn an income over this time, and why, if everyone else was able to go back.
No, there's a lot of merit in that, and I think as the economy gets opened, it raises a lot more arguments about the rationality of those which are not been open. So those industries which have not been open. So people are saying, listen, you've opened hairdressers, but you haven't allowed gyms, for example. What's the difference? Why can someone be up in your face and cut your hair, but I can't run on a treadmill which is 1.5 meters apart from the next person who's running on another treadmill? And then so the argument about the rationality of those which are still left out in the cold becomes a lot stronger as more industries are allowed into the fold. Anyway, if I can move on from that, that's actually a very good point to ask that question, Matthew, because I'm now going to go on to sports, arts, and culture directions. There are 2 sets of directions. The first set of directions relate to the arts and culture sector predominantly. So the ministry deals with sports, arts, and culture together, but the directions have been issued separately, as one for sports and one for arts and culture. The one for arts and culture basically provides guidance for productions using local cast or performers and crews during alert level 3. And it amends previous mitigation measures for the sector, which provide for alert level 4 restrictions. Performing arts institutions or playhouses now, so you're looking at your Artscape, your Playhouse Theatre in Pretoria, those kinds of places, may provide content for streaming and live streaming without audiences. So provided that those institutions are being used to filming, for streaming, that's fine, but you can't go to the artscape and watch the ballet performed sitting right next to people in the audience, because that would obviously be a gathering which is unlawful. They require that minimal cost and tech support are used. Compliance officers and other health protocols previously published are to be complied with. And as I said earlier, there's no provision for live performances at theatres. Film and television productions using local cast and crew is also allowed for, but again, all health protocols and social distancing measures must be adhered to. A maximum of 75 people are allowed on set, and the other standard COVID protocols apply. And then they also deal with music recordings for local broadcast, streaming and digital platforms, and finally, it deals with performing arts, streaming events, poetry, comedy, dance, literature events, online workshops, e-learning. All of those kinds of things can be implemented. Then the second set of directions, which have been issued by the Department of Sports, Arts and Culture, and I think a lot more South Africans would be interested in this, deals with the sports sector and what kind of sports may be practiced, what people can do, whether people can train, those kinds of things. It amends the original directions to allow for professional non-contact sports as defined in the direction. So if you enjoy fencing, I suppose is a contact sport. If you enjoy running together with a whole group of people, but you do that for fun, you wouldn't be allowed to do that because that's not professional. And it also allows for professional non-contact sports matches to take place in a stadium without spectators. So those of us who love our football are quite used to seeing this on TV. You have these big Italian clubs and English clubs playing with no people in the stadium at all. So we will probably see a similar kind of thing happening in our country. These directions make provision in Annexure A for specific non-contact professional sports bodies to resume matches. These bodies are, I'll run through them very quickly: archery, athletics SA, baseball SA, badminton SA, canoeing SA, cycling SA, equestrian SA, but no cross-border training, golf SA, gymnastics SA, rowing, sailing, shooting, table tennis, triathlon, volleyball, softball, anglers and casting confederations of fishing, snow sport. I'm not quite sure where the snow is. I suppose there is snow somewhere in South Africa. Chess South Africa, cricket South Africa, bowls South Africa, squash South Africa. And yes, I know you've all been waiting for this. Yipske and the Pigeon organization are also allowed to operate. So, yeah, that's good news for those federations.
Listen, does this mean that the government has finally pronounced on the much debated question on whether or not soccer players are allowed to touch each other?
They haven't gone that far. But I think soccer is one of the sports which is allowed. No, it's not, is it? I didn't actually look at it as carefully.
It'd be interesting to know that the minister, who obviously is of firepool notoriety, has now brought to bear his mind on whether or not soccer players do in fact make contact during games.
Yeah, well, it's interesting that soccer itself is actually, I mean, it's actually conspicuous by its silence or its absence, at least.
I mean,
I suppose it is. Yeah, I suppose it is a contact sport. So that's exactly why. Yeah, you're right. Sorry. The other interesting thing is only athletes, support staff, and officials under the age of 60 and tested for COVID-19 with no comorbidities are allowed to participate. So you would have remembered I said earlier that in the hairdressing industry, they said that if you have comorbidities, you are encouraged not to come to work. Here they're actually saying if you're over 60, I suppose that wouldn't be athletes, but support staff and officials. And if you have any comorbidities, you are not allowed to participate. So I found that an interesting one. And then finally, it also makes provision in Annexure B for specific professional athletes to resume training. And this is basketball, fencing, football, handball, hockey, rugby, non-contact training methodology, I'm not quite sure what that is, figure skating, athletics, ice hockey, motorsport, and netball. So I suppose here we have football involved, and they obviously see this as a contact sport. So Megan, you get the prize for pointing that out. And rugby, of course, many South Africans would be very happy to hear that at least their athletes can start, their rugby players can start training and getting themselves in shape. Yeah.
I think it's also I think it's worth mentioning that, you know, Ramaphosa spoke on the 17th of June, and he mentioned sort of a lot further, more and rapid opening of sports and activities. The regulations that we are discussing came out on the 11th of June. So although it wasn't clear, it does sound like, as with restaurants and Airbnbs, etc., we are waiting for a further set of regulations to come in the next few days.
Yeah, hopefully. I'm desperate to go on holiday, and I'm waiting for those regulations to say I can go and stay at a hotel somewhere far away from Cape Town, but not outside of the province, I suppose. Okay, that basically sums up what I had to say about the regulations which have been published. As I mentioned earlier, we're still waiting, and as Matthew also touched on, we're still waiting for further regulations relating to restaurants, cinemas, and holiday accommodation. But I'm sure just keep an eye on our website, because we are often, if we're not hosting a webinar, there definitely will be an article on it, and you'll be notified of it. But Megan, can you take us on to the questions which have been posed over the past couple of weeks?
Yeah,
a couple of days, sorry.
Yeah, and then, just if anyone is out there who has questions, please feel free to pose them in the question section. If we don't discuss it on this webinar, we perhaps might give you a short written answer. Otherwise, you're welcome to contact us after this.
Yeah, cool. So basically, we all discussed this before, that a lot of the questions seem to be around the fact, and we've already addressed this, that people are not quite understanding and not quite sure after the speech, what does it mean? Does it mean the regulations have now changed? Are we in alert level 2? You know, what is exactly happening? So a lot of the questions that came through were around that sort of misunderstanding of the regulations. So we've already dealt with the fact that the regulations are at the moment alert level 3 as they are, until they're going to get amended by the minister. So some of the questions were, for example, are social gatherings now permitted? So for example, can I go to a braai? Can I go to church? Can I go to a coffee date or something like that? So exactly what I just said, what we just touched on now. So the social gatherings are exactly the same to what they were, unless they have been amended in the directions to be issued coming out. So it's still prohibited to have a social gathering, and the exceptions are still faith-based institutions, funerals, workplaces for work purposes, agricultural auctions, and then professional non-contact sports, which Lucian's already touched on. And then an interesting thing which we did touch on last week, but or last seminar, which was said quite fast, but there is in the alert level 3, which is slightly different to what it was in alert level 4, was an express a regulation that says the enforcement officer at a gathering must order the people at the gathering to disperse, and then only if they refuse can they take the appropriate action, for example, arrest and detention and stuff like that at those social gatherings. And then we did have some of the questions around churches and stuff, and I'm not going to go into too much detail about that. There was directives issued on the 28th of May, which came into operation on the 1st of June. Just an interesting sort of note on that. I'm not sure, Lucian and Matt, if you guys have read these or whatever, but it seems like there's quite a massive duty on the religious leaders and the people in control and in charge of the religious places. or the way that those directives are sort of worded seems to place the duty on them. So they are to ensure that there's no physical contact. They are to ensure that everyone wears their masks. They are to ensure, so there's a 2-hour limit on it with a 30-minute intermission in between. It's just, I just thought it was interesting that it wasn't for the people going to these places of worship, that they're almost, I don't want to say don't have a duty on them, but
yeah,
it was just when I read that.
I think it goes from an enforcement perspective. It's a lot easier to target the person who runs the place than the 50 people who are sort of there and can disappear quite quickly. And it also makes the owner, or not the owner, but the head of the establishment a lot more vigilant when people come in at their doors. Because if it's up to each one of those 50 people who are allowed to be in that room to be responsible for themselves, it's a lot harder to enforce. So I suspect that's maybe it. And I think the offence is committed by the head of the religious institution, presumably, if it is found that there are people without.
It seems so. It seems so. Yeah. That's how I interpret. I mean, it's quite stringent and quite rigorous as to what you think. But I don't know if maybe because it was the first sort of big social gathering. I mean, apart from funerals before this, but it feels like it was maybe one of the bigger steps forward. That okay, you can go to church now. You can go to your mosques and your synagogues and stuff, because the directives and stuff are quite strict. Like every person who enters the place of worship has to be screened, and every person is required to provide a report. And I just thought maybe it's quite interesting for just a thought of when we go back into students going back to school and kids going back to schools and stuff, is that maybe going to be how they're going to deal with those kids going back, and maybe the parents having to say, like, sign a form, or those sort of things were going through my head. I don't know what you guys are thinking that.
I think one of the things that I found with the opening of places of worship and religious gatherings is, as Lucian said earlier, it raises some very important discussions or considerations as to the rationality. So you both will know that there was that very nice Shapiro cartoon which came out of Ramaphosa speaking with his mask on, and the comment says it's still too risky to gather with your friends, except when about 50 of you share an imaginary friend, in which case please feel free. And I think, talking to the rationality, essentially this is now saying that persons who wish to gather in a congregation can do so with 49 other people. It's still limited to 50. Thank you, Lucian. So I think you're faced with a conundrum here where parties who happen to be religious are allowed to gather with 49 other persons at once, whereas strictly speaking, at the moment, I'm not allowed to visit one other person in my neighborhood, be that, my mother, my friend, my family relative. And I suppose in as much as religious rights are recognized in our Bill of Rights, parties also have a right to be agnostic and atheist. And then is there perhaps discrimination happening against those people? Is the prohibition of movement, is it rationally connected to the outcome? I think these are questions perhaps I'll cover a little bit more in my challenges section.
Well, I was just going to say that what you've just raised there came up in the De Beer case, which was, it was the De Beer and the Liberty Network.
Liberty Fighters Network.
Liberty Fighters Network, who challenged the regulations as a whole as being unconstitutional. In the court, the North Gauteng High Court, which is the High Court in Pretoria, basically set aside all of the regulations, save for a couple of issues relating to the prohibition on smoking and the prohibition on evictions, and I think a couple of other things. And one of the arguments that the judge used, and I don't want to sort of rain on your parade, Matthew, because we're going to discuss this later, but one of the issues that the judge raised was the rationality of allowing people to go to church or going to a funeral, but not allowing a wake the night before. Why do you allow the one and not the other? And like I say, I do have a little bit of sympathy for the government, because the more things they allow, the harder it becomes to justify not allowing other ones. But anyway, Megan, please go ahead. Questions, yeah.
But I mean, also, I thought it was quite an interesting thing, like what you're saying, kind of one of the very, very, very small clause in the, or regulation in the directive says, religious organizations should, where possible, convene services through virtual platforms, online or social media. So it almost feels like a weak, maybe that's just my personal opinion, a weak attempt at, like, if you can, do it through virtual platforms, but if you feel the need to go to church or whatever, then you can go to church, but it's quite strict if you read these directives. I mean, yeah, like obviously no personal physical contacts and stuff like that, but it goes into a lot of detail of, you know, what you need to do and what happens and who's responsible, and I just thought it was quite interesting. We'll see when the other regulations or the directives come out after the president's speech, if they're as onerous and quite detailed as these ones.
Yeah.
That's that. Then there was also some questions about whether permits are still required and stuff. They are still required under the regulations.
What kind of permits? Just explain to.
So people are wondering if the employees going to work are still required to have permits. They are required to have permits in terms of Regulation 33, which deals with the movement of person. It deals with the movements of people between provinces, metropolitan district areas, and hotspots. And it says it's prohibited unless you have a permit. And key to that permit is a form of identification. So if you're going to work, the form is a Form 2 of Annexure A. And then just a note on for students who are going to be going, hopefully for them, sometime soon. I'm not sure if any, I don't know if you guys know of any varsities that are actually back. But students who have between provinces to attend lectures, there is a form that you need. It's a Form 3A of Annexure A, which is also needs to be provided by your head of institution.
It actually doesn't even apply. It doesn't only apply to universities, but schools as well. You think of kids who have boarding schools, who live in other districts, other provinces. The schools have to issue. The head of the school has to issue a permit for its learners returning across provincial and district.
Yeah, and actually the people who are also transporting those students also need to have those permits in place.
If I could just add something to that, I know that in the earlier alert level 4s, there was a heavy emphasis on companies issuing certificates, companies being in possession of certificates. So there was a time when there was a sort of duality in the documents that you were required. You needed a Form 2B in terms of the regulation, and you needed a certificate from the Companies and Intellectual Property Commission stating that your company provides essential services.
Yeah.
And there was a judgment that came out. I haven't actually studied this one. I just took note of the effect, and essentially the court found that the Companies and Intellectual Property Commission, insofar as it serves as a sort of central registrar for companies, is not a competent authority to determine the services which each and every company in South Africa provides. And the judgment also mentioned that, you know, in the case of a sole proprietor, you are in some ways discriminated against because you're not going to get a certificate from SIPC, even though you, in your capacity as, you know, either in a sole proprietor relationship or in a partnership or any business entity structure which isn't administered by a SIPC, you essentially stopped from trading because one of the certificates that you were required to have in terms of the previous regulations was not possible for you. So that now has been done away with, and as far as I'm aware, you only need the certificate in terms of the Disaster Management Act regulations.
Yeah, that's how I understand it as well.
Yeah, agreed.
Cool. And then, yeah, just some of the other questions was, are curfews still in place? No, the curfews are no longer in place. It's just for the exercising is still in place for now. We'll see what happens after the directives after the president's speech get issued. An interesting question that I thought maybe, are we going to end with it? Yeah. One of the clients asked, how do we keep up to date with the regulations and the directives? And it was a comment that it was sort of unavailable or time consuming to monitor all the sites and stuff. And I think that the crux of that comes down to the frustrations around the regulations and how rapidly they are, well, not after the president's speech, and now we're still waiting a week after that speech, but once they all do sort of come out, it's quite rapid, and just keeping up to date with all of that. Some people have found that it's quite difficult to get hold of, so I think that's just adding to a lot of people's frustrations through this whole, I would say the whole 3 months, and all the different levels. And now we're having we're just chatting about this actually this afternoon, saying it's level 3 that's being amended, and we're not going down to level 2. So what does it mean? How is the amended level 3 going to be different to level 2 and level 1? And what does it mean when we go back to level 4? We're going back to level 3 as it is now. It's a very confusing time for everyone to be in. But we did. We as legal practitioners obviously have our access to our online stuff, but LexisNexis is a platform which is free, hey Matt? They've got...
yeah, I've just posted 2 links. Sorry to interrupt, Megan.
No.
So the link that I sort of consider authoritative is the Government Printing Works, because all gazettes need to be published there. So I've posted a link for the separate gazettes, which seems to be quite up to date, you know, within an hour or 2 of what is actually published in the Gazette. And then if you are looking for a slightly more organized, more logically arranged resource for the latest regulations, and I've found the LexisNexis COVID-19 Resource Center very helpful. It is available, it's a free resource. So LexisNexis really came to the party during the crisis. I remember they had that Tumamina initiative, and a few of us submitted articles to them, and they have made a very nice detailed resource center available to the public, and that link is also included in the discussion here.
Very cool. Yeah, and also the government website also has quite nice. Maybe I should post that one as well. That was quite an important question I thought we should deal with. But otherwise, let's get to the fun, juicy stuff, Matt.
Just before you do, a question was posted, which I've answered online. I've typed out the answer, but the question was regarding permits for employees. The question was, are they no longer required, and are they only required if employees are crossing provinces or hotspots? My understanding, as I've typed, is no, they are still required. There've been no regulations which have retracted that particular requirement, but I think in practice you're going to find that they're not going to be enforced much, because so many people are on the road traveling to work now. The economy has opened up so vastly over the last few weeks. It's not like when we were in level 5 and only essential permits holders could go to work. You're probably not going to find people in the government enforcing it. So I hope that answers the question.
Yeah, I agree. So, as I understand, it's regulation 33(4)A, and its movement between provinces, metropolitan areas, and districts and hotspots is prohibited, except for persons doing so while carrying out permitted work, and provided that such person is in possession of a permit. So, as I read it, it's if you are crossing those areas, then you do still need a permit.
Yeah. Okay. Great. Moving on to Matthew.
Yeah, so I mentioned some of the legal challenges that were afoot at the during the previous webinar. Again, I think given the time, we've got about 15 minutes. Sort of detailed discussion of each one is beyond the scope of this webinar. I'd just like to touch on the ones that I find very...
You sound like such a lawyer, honestly. Sorry, keep going.
I think last week I was accused of being a nerd, so a lawyer is somewhat of an improvement. Thank you.
Stepping up.
So yeah, I think the one that really got the public's attention was, as Lucien said, the Liberty Fighters Network judgment that came out of the North Gauteng High Court on the 2nd of June. That case was brought by Reino de Beer, who is the chairman or director of the Liberty Fighters Network. I'd actually read that challenge prior to the previous webinar for brief discussion, and I hadn't listed it as in my book as particularly strong challenge. So it tells you how much I know about these things. But the North Gauteng High Court and Judge Davis delivered quite a scathing judgment against the government's action, and particularly the Minister of Cooperative Governance and Affairs, Dlamini Zuma, in finding that the entirety, almost the entirety of the lockdown regulations were irrational. And Lucien, I'm so glad you didn't quite steal my thunder, because I enjoyed two quotes from that judgment. The first one, which you came dangerously close to sharing earlier, was that it seems irrational that if your close family, friend, or relative is dying, you're not allowed to visit them. But if they do die, then you and 50 of your friends going to have a party about it. Obviously, when you phrase it like that, it seems beyond belief that was thought to be rational. And the other one, which I really enjoyed, was that the judge who is sitting in Pretoria noted what's going on in Sea Point and said that surely it can't be rational that hundreds of people can parade themselves on the promenade, but were you to put a toe on the sand of a beach, then there'd be a massive outbreak of the virus. So I'm paraphrasing, but I thought it was two very key observations. And as you said, Lucien, as you unlock parts of the population and different activities, then it causes you to gaze at some of the other ones, and you realize that there might not be a rational connection between the purpose of the prohibition and the law that has been passed.
If I can just,
it feels like you're about to say something. Yeah.
No. So it's interesting that you raised those questions, because, those extracts from the judgment, relating those to that sort of almost anecdotal kind of example of why the regulations are irrational. Because it was that very argument which has been used in the court in the application for leave to appeal, which was heard yesterday, I believe, where the minister is asked to appeal the matter to the Supreme Court of Appeal, and has asked the judge who made the judgment to grant leave to appeal. And one of the arguments which the advocate used, and it's a very, very hard-hitting advocate, Wim Trengo, who's very well known as a senior advocate in this country, he said that the use of these anecdotal arguments or examples as to why certain provisions are irrational, and then to wipe out the entire regulations on the basis of that, was essentially what was said by the judge was, well, this seems irrational, and therefore everything, he threw the baby out with the bathwater. And that's one of the bases in which they're appealing it. And Trengove said, how does the minister conduct herself, how does the minister rectify what the errors when you don't explain what the errors are? You just give us a couple of examples and then say everything else is therefore irrational. So I think that there's a really strong chance that this will get overturned. There are other arguments which have been made, which I don't want to go into because they become quite technical, but I think that there's a decent argument to be made that a leave to appeal will be granted. I'm absolutely certain that it will be. If not by this judge, then leave will be granted by the SCA, the Supreme Court of Appeal. And I think that there's a reasonable to good chance that it would be overturned. The actual decision will be overturned on appeal. But anyway, go ahead, Matthew. Sorry, I just wanted to put my 2 cents worth in there.
Yeah, so I think I, along with many South Africans, are quite excited about that judgment because, the headlines read, and I think the Dingy Marshall article read, the lockdown is unconstitutional, the lockdown is irrational. But I completely agree with your sentiments. the blanket declaration of unconstitutionality and invalidity, which is paragraph 1 of the order, raises a whole lot of questions, because if you look at how the challenge itself was structured, even the liberty fighters didn't address each and every regulation. And I think that a better, let's be careful what I say here, but I think a more carefully crafted application, which addresses each and every regulation, might have been more successful and perhaps unassailable by government. Because as we said, if you look at the regulations on funerals versus the regulations on gatherings of one-on-one persons, that to me and you and everyone at home feels irrational. It feels wrong. And our law, and particularly our constitution, is essentially a reflection of Bernie Mora's, the public,
the morals of society.
That's the word I'm looking for. Thank you. And so, I think we all feel that something is wrong there, and when the lawyers put their heads down, they can come up with a legal solution which indicates that. But that judgment didn't have a sort of regulation versus irrationality, regulation by regulation analysis. It was this sort of blanket judgment, which perhaps leaves the judgment open to challenge. So, yeah, the practical effect of that judgment at the moment is almost nothing, because in terms of the judgment, the Minister, Dlamini Zuma, was given 14 days to redraft the regulations with if you look at the wording, it was in a manner which, with due consideration to the limitation of each regulation has on the rights guaranteed in the Bill of Rights, which is, as you say, it's quite a wide mandate to a minister, who then has to essentially go through I don't want to say legislative, because she's not the legislation, but she has to redraft rules in quite without too much guidance from the courts. So that judgment was taken on appeal, and as you say, it was argued yesterday in the Pretoria High Court, or the leave to appeal was argued. And for those out there who are unfamiliar with the process of appeal, essentially, as soon as the notice of appeal is lodged against a judgment, in this type of judgment, then the suspension of the order, the effect of the order is suspended. So there currently isn't, the regulations as they are in force. There's no order of constitutional invalidity which has undone that.
Matt, can I ask a question?
Yeah,
sorry.
Sure.
So just about what would have happened if we'd moved into level 2 last week? What would have happened? What would the effects of that have been?
Because of this particular judgment?
Yeah, like what would it not have meant that there's almost no point in continuing with the judgment, or would they just have gone through?
Well, I can tell you exactly what the wording was. That the regulations, so that all of the regulations, regardless of alert levels, are declared unconstitutional and invalid. Which is another reason why there's a problem with that judgment. How can you make a regulations invalid which haven't been promulgated already, or yet? Sorry, not already. I think with all due respect to Judge Davis, and it's not Dennis Davis from down here, it's I think it's Nathan Davis in Victoria. I think that he felt that the regulations were wrong, and he therefore wanted to find a decision. He wanted to find a decision, but then had to work out the reasons for that decisions afterwards. I better be careful. I did say with all due respect before I said that.
Okay. Well, as long as you covered your bases, I think maybe just to sum up, what the government was faced with the judgment. To my mind, it's the first of many hardcore legal challenges that have come. As you mentioned earlier, the government has faced 116 legal challenges to the lockdown, during the lockdown, which is, it's an insane number. It's you can't imagine that they're going to survive all of them. And I think that a more strategic and thoughtful idea might have been, and I think this may have had the effect of diffusing some of the other challenges, is to take the North Gauteng High Court judgment as sort of a reason to redraft the regulations, to pause for thought and realize that even though the formulation of the judgment was perhaps strictly speaking perhaps too broad, the judge did make some very good points. There has been a trampling and a prohibition on many of our constitutional rights. So, use this as an opportunity. You can do it without, while saving face in the public. Go back to the drawing board, issue a new set of regulations. And in so doing, you would essentially render a lot of the other challenges moot. A lot of the other political parties would be stopped from, scoring cheap political points by getting easy victories. And for what it's worth, I think the other challenges are much, much stronger than this one. So it's a Pyrrhic victory. You are winning a small battle now to go and lose 2 or 3 later. I don't really agree with it.
That's kind of why I was asking, is if they have to come up with regulations in terms of alert level 2, would it still be covered under that judgment that it's unconstitutional? So say they, instead of amending alert level 3, if they just...
So this one would, because of, as Lucian said, paragraph 1 says the regulations promulgated, doesn't say which alert level. So it would, but if you look at the other challenges and the sort of the content of the other challenges, I realize we're running dangerously low on time, so I'm going to sort of fly through them. If you look at the progress challenge, which is essentially 8, I believe they're students from UC, and they obviously have some significant financial backing because they seem to have quite a heavy legal team on board. But their challenge, they're calling themselves the Progress Group. Their challenge really centers on the formation of the NCCC, which I think is the National Corona Command Council. And yeah, I mean, we have the issue there where this sort of body, which has in many ways supplanted or replaced cabinet, even though it is constituted largely by cabinet members, is now performing cabinet functions. It also, to a large extent, has replaced the function of the National Disaster Management Center. So it's a very interesting challenge. You would have seen the NCCC has received quite a lot of attention in the news. I think the answers that Ramaphosa, Kize and other officials have given in public as to the composition of the NCCC has left a lot to be desired. We are told that it's, in its initial formulation, it was essentially the nut joints, and it's really the more heavy-handed ministers which seem to have made themselves, made their way onto the council. So it'll be interesting to see how that challenge progresses. I just want to check. So that one was argued on the 15th of June, and that was in the Western Cape High Court. So judgment was reserved there, and we might well be getting a judgment in the next few days that was brought on an urgent basis. Lucian, it looks like you have a comment.
Yeah, I think we've got about 30 seconds left before we finish, but I wanted to sum up what you were. Something struck me while you were presenting on these constitutional court challenges. I think it's a nice way of concluding, but I don't want to stop you if you've got one more thing to say.
Okay, I'll just mention the 2 other challenges which I consider significant at the moment. We don't really have time to look at the British American Tobacco and FETA challenges, but those have both been heard. So for the smokers out there, Batsa versus the Minister of Cooperative Governance and Affairs was argued in the Western Cape High Court on the 22nd of June. the FETA challenge in the North Gauteng High Court on the 10th of June. There's possibly some respite on the horizon for smokers. Very, very briefly, the two challenges, just to sort of bring this to a close, that I'm most excited about come from the Helen Suzman Foundation and from the Democratic Alliance, for no political reasons, merely because they both go straight to the Constitutional Court. The DA applied for direct access and has granted it. I'm not actually aware of the current status of the constitutional challenge of the Helen Suzman Foundation. But yeah, Helen Suzman Foundation takes sort of a separation of powers point and really talks about the failure of Parliament to provide oversight during this period. And the DA has taken aim at the Disaster Management Act and really its effect at in some ways replacing Parliament, and tries to get the rules which have been published in terms of the Act to be scrutinized by Parliament. So it's three very different angles, three very different challenges. I think all of them have quite strong merits, and yeah, I look forward to reading those judgments in the next few days and weeks.
Cool. Yeah, the last thing I want to say is I think that even if these judgments, even if these court cases are not the strongest, what they do is they enforce the separation of powers and the oversight which each body of government has in respect of the whole. So the courts, so the executive is not going to make laws very easily and very blithely and without considering them, because they now see that the people of South Africa are actually standing up and going, hold on, you can't just take away those rights. Let's look at what you've done and let's look at it with a microscope and see if it's right. So even if we don't win, if litigants don't win in challenging the government, I think the government is going to be very careful about how they draft regulations in the future, knowing that there's such a robust way of looking at them and examining their conduct. But yeah, so that was my conclusion. Thank you very, very much. I see we've got a Q&A. Yes, just a thanks to everybody, I think. Thank you very much, everybody, for your time. It was, once again, we really enjoyed it, I think. Every time we have presented, we've really enjoyed our time. And I hope it has been enjoyable for you and informative. And if you have any further questions leading up from this, please feel free to pop us an email. You can find us on our website, dingleymarshall.co.za. And yeah, pop us some questions. Maybe let us know whether you enjoy it. Maybe let us know what you'd like to hear about in the future. Because we definitely are going to be continuing this in weeks to come.
Yeah, and then maybe just to say again, those links that we discussed are in the panel discussion here. And then for those wishing to listen or share this webinar, it will be available on YouTube and on our website.
Great. Thanks, everybody.
Thanks, everyone. Good night.
Cheers. Bye-bye. Good night.